Hi guys, continuing our answer writing series, in today's video we will discuss another question. In India, the judicial activism is on the rise. Examine. It is very important. You can write an essay on it as well as from the general studies perspective, and all those people who are having political science and public administration as their optional, this question is very essential. So the judicial activism is on the rise because of many reasons. The reasons are near collapse of the responsible government, because in certain parts of the India, means the government is not taking action. That is the reason why judiciary is taking proactive measures. Pressure on the judiciary to step in the judiciary, because there is a pressure, because the people, the citizen of the nation believe in judiciary. They tend to put pressure on the judiciary to act proactively. Then near collapse of the responsible government. Sometimes judicial enthusiasm to participate in social reform and change. Sometimes individual judges, they try to participate in social reform as well as change. That also leads to judicial activism. Legislative vacuum left open. Sometimes what happens, the legislative vacuum lead to judicial activism in India. Then the constitutional scheme means the Supreme Court is the guardian of the Constitution of India. That is the reason why they also take power to do certain kind of activism. Authority to make declaration as to validity of law. The government, the Supreme Court of India has assumed the power to decide whether any law passed by the Parliament is valid or invalid. After the passage of Bharati's judgment and the emergence of basic structure of Indian Constitution in 1973 onwards, the Supreme Court has assumed itself the power whether a particular legislation passed by the state legislature or the Parliament is valid or invalid. They have assumed the power. Enthusiasm of individual players. Certain judges are individually enthusiastic to take action, and that is the reason why they also participate in judicial activism. Then we will come to where was the first time in India the judicial activism started. It started pre-independence era. That is, the first case of judicial activism in India was the Justice Mahmood of Allahabad High Court in 1893. High Court on the case of an under trial who couldn't afford a lawyer. Means Justice Mahmood was the first person in pre-independence era where he himself took part in judicial activism. Some person, a particular convict, he was unable to afford a lawyer in that particular thing. In the post-independence era, what happened in A.K. Gopalan versus State of Madras, the Supreme Court has the power. The Supreme Court declared that we have the power to decide whether a legislation passed to be valid to the extent it transgress the limit. The validity to be decided by the Supreme Court in A.K. Gopalan case. It is the starting point of, it laid the foundation of judicial activism in India. Then another important case in 1967, Golaknath versus State of Punjab, the court held that the Parliament couldn't amend so as to take away or abridge the fundamental rights. The court held in this particular case that the Parliament couldn't amend so to take away the power, the fundamental rights. Means it held that Parliament is cannot take away the rights of citizens. Then another best example of judicial activism came in the 1973 Kesavananda Bharati versus State of Kerala. The Court assumed itself the power to determine the validity of a constitutional amendment act effected under Article 368. It is one of the finest judgment which was delivered by the Supreme Court of India, and it held that even a constitutional validity will also be decided by the Supreme Court whether it is valid or invalid. Then, directing the political leaders and bureaucrats to compensate the state for abusing discretionary powers vested in them once the Supreme Court has refused to exercise. Sometimes what happened, even the discretionary power, that is the breeding ground of corruption in India, whether it was vested with some political leader attaining high post like chief minister or any minister or prime minister or any other minister in the central government, or certain bureaucrat to act in discretion, that the Supreme Court held that you have to compensate the state in whatever decision that you have taken. That means it's a wonderful case of judicial activism. Then once in one of the Ayodhya judgment, the Supreme Court refused to give advisory jurisdiction under Article 143. That is another kind of a judicial activism, I would say. Then Supreme Court has broadened the scope of locus standi in the matter of enforcement of fundamental rights. Credit of judicial activism in India goes to Justice Bhagwati, Justice V.R. Krishna Iyer and Justice Kuldeep Singh. These are the three judges who were the pioneer of judicial activism in India. Then further scam against Lalu Prasad Yadav was monitored by the Supreme Court as well as respective High Court. You can imagine the level of judicial activism which taken place. Then judges appointment case in 1998 held a CJI to consult four senior judges before advising the any appointment to the Supreme Court or any appointment. The court stressed too far and directed union of another case. The court stressed itself too far to directed Union of India to enact uniform civil code. And the most recent example you can give by saying that National Judicial Appointment Commission 99 Constitutional Amendment Act struck down by the Supreme Court by saying that it is a violative of the basic structure of Constitution. It's going too far in that particular direction. You can sum up by saying that judicial activism, though it started in the pre-independence era, it has done more good than harm, because it has enhanced people's trust in the judiciary of India. Now moving to the next question. Next question is, Indian secularism is a type by itself. So how? In this question we have to address how Indian secularism is different from the Western mode of secularism which are adopted and practiced by Western nations. Western model of secularism is based on the separation of church and state. Indian idea of secularism is based on the idea of inter-religious equality. Our founding fathers believed in the principle to safeguard multiple religions and their practices in India. In Western countries, their secularism is based that church is different from the state, and state is not having any role to meddle in the church's affairs. But Indian founding fathers thought that Indian secularism has to give equality to all religions, because India was a melting pot of various religions as well as culture and communities. Then Indian model of secularism is far superior to Western model by giving more importance to equality among religions. Means among the religions there is equality, which is propagated by Indian mode of secularism. Indian secularism is different from Western model by opposing evil practices of all religions like oppression of Dalit and women within Hinduism and discrimination against women within Indian Islam and Christianity. Wherever there is oppression, Indian secularism is always opposed to that, whether it is untouchability practices in Hinduism or oppression of women in Christianity as well as in Islam. Then Indian secularism is also safeguarding the minority against onslaught by majority. In the perspective of our secularism is different from the Western counterpart. In Indian secularism, our minorities are being safeguarded against the onslaught of the majority. Majority community shouldn't violate against the minority communities. Indian state is always keep a sharp watch on this. Then Indian secularism also deals with religious freedom of individuals within the minority community. Individuals has the right to profess the religion of his or her choice. Article 25 clearly mentions that religious minorities also have the right to maintain their own culture and educational institutions. It is there in our article number 29. Then Indian secularism is made room for the state supported religious reforms. Indian secularism also is giving state supported religious reform, but there is restraint that to what extent they can do it. Then Indian secularism opposed to religious tyranny as evident against the untouchability prevailing in Hinduism. Indian secularism is based on equal respect for all religion. All religious festivals are celebrated by Indian government. We believe in the principle of Sarva Dharma Samabhav. So Indian secularism is totally different what is practiced by our Western counterparts. And I hope this question will help you to write answers on secularism, and thank you very much.